I found a nice bench today because I want to talk about something called the bench book. What is the bench book? It's the guide given to judges for how to conduct trials and proceedings. It used to be confidential, but now it's available online. Also, there's been a bit of a name change. The more technical guides are now called compendiums, so you have like the Crown Court compendium. But there's still something called the Equal Treatment Bench Book. The technical stuff, like the compendiums, they give things like standard directions to give to juries for every conceivable offence, you know, the idea being that there is consistency. But the equal treatment books, they sort of like deal with how to just conduct yourself generally. And they warn against things like sort of implicit biases or unconscious biases. So for instance, generally speaking, a lot of Western cultures, looking somebody in the eye is seen as a sign of honesty, and not looking somebody in the eye is seen as being evasive. But in a lot of cultures, looking somebody directly in the eye is considered rude, especially if they are in a position of authority. To show deference, you avert your gaze. So that could be dealing with a judge or with counsel in court. So judges are reminded to take these sorts of things into account, and perhaps to warn juries as well if necessary. But why has this arisen now? A couple of interesting cases. Now, you may be familiar with Lawrence FAQS because he's always in the news. He is embroiled in a defamation matter at the moment, and he applied for a jury trial. Now, in olden days, pre-2013, that was the default position. You got a jury. But the 2013 Act removed that presumption that there would be a jury. And the general consensus is, while there's a theoretical possibility for a jury in a defamation trial, there hasn't been one in the last 10 years. I've been involved in a case, unfortunately I can't really talk about it, where I thought there was a backdoor way of getting a jury in, but maybe one day I can tell you. But anyway, what Mr. Fox's argument was, he basically is suing people for accusing him of being a racist. And his argument is thus: the Equal Treatment Bench Book covers racism, but that approaches it from an outcome point of view. So it says racism isn't necessarily something intentional. It can arise from unconscious biases or just the way society is structured. You know, you get a lot of this sort of institutional racism idea. So the idea is you just look at what the outcome is, and if the outcome causes a detriment or less preferential treatment to people from a particular race, then it is racist, and it has very little, you know, intent is not magic, as we say. So Lawrence FAQS's argument is, well, hang on, I am being accused of being a racist, and I think that should be decided by, you know, how society uses that word. I mean, we get a lot about what we call dictionary definitions, because you know, the dictionary definition of racism is just showing animus to somebody because of their race, whereas sociologists would say, no, racism is prejudice plus power, not merely prejudice. So you get into all these sort of strange sociological and philosophical debates. But his argument is, well, look, the bench book effectively says it's got nothing to do with whether you intend to be racist. So anything that somebody judges or perceives to be racist, you know, that's what we call the Lawrence test. If somebody thinks it's racist, then it's racist. So your hands are tied, judge, and you have to find in accordance with the bench book, and that just doesn't seem fair. So it should be 12 good men and true, or women. That has been rejected, though. And the argument seems to be that the judge will effectively apply two separate tests. He will say, well, yes, this is how I would deal with people in sort of a wider context, but for deciding this particular issue, I will put myself into the mindset of your average, reasonable, hypothetical reader or viewer. But there's been another interesting case that's sort of in a very similar thing. It's a trial about whether somebody can be penalised for gender-critical views, okay? And, you know, without getting into the huge debate about sort of transgender issues and rights there, because that's obviously a very complex and controversial subject. But the argument is, well, gender-critical views, they're what we call a protected belief, therefore I can't be penalised. However, the judge at the start of the hearing asked for everybody's pronouns. And that is something that the bench book does cover, although what it actually says is, it says, well, look, most people will present according to the gender they identify with. So if somebody is clearly a cis woman or cis man, well, you can probably make the assumption that they'll be happy with sir or ma'am. And if somebody is trans, and we're getting, get into all awful things like about whether people can pass or stuff, but the general idea is if somebody comes presenting in a very stereotypical feminine or masculine way, then that's probably safe to assume that's how they'd like to be addressed. But if the issue arises and they raise it, then you should respect that. But this judge has asked from the outset what people's preferred pronouns are. So the argument there is, well, hang on, you've already effectively come down, quotes, on one side of the ideological debate. Now, whether or not that is true or not, that's a wider matter than somebody like me to discuss. But I just thought you might find that interesting then, because there is this tension, because obviously the court service is set up to be very friendly and inclusive and to respect diversity and respect other people's views. And the general consensus is you address people how they wish to be addressed and you don't address them how they don't wish to be addressed, and that just applies generally.